Good evening. This is John Milburn for Law's 11057 Introduction to Law. This is Term 2, 2017. We're into Week 4. The main topic for tonight is legal thinking skills. We're going to work our way into legal research, and I'm going to recap in relation to some of the aspects that we did last week about sources of law in Australia. Just a reminder for those of you that haven't uploaded your first assessment, it is due this Thursday, the 3rd of August. I believe it's the 3rd of August, this Thursday, 11:45 p.m. is the cutoff is the due date, and there will be late marks attributed, 5% per day for any late submission. Please don't be late. It's really, once you've mastered the technology, the task itself is really quite simple. I don't need anything extravagant, but there are some guidelines. I want it to be professionally presented. So it doesn't have to be a long, lengthy document, and the number of words that we've mentioned is purely indicative to give you some idea of the level of effort, and I know that's a bit obscure at this stage. So the task is really to present your portfolio in a manner that works for you, and bear in mind that this is going to be a platform for ongoing contributions by you during your course. I would encourage you, even at this stage, to think about doing the third year subject, which is professional portfolio, with Associate Professor Scott Beattie. And the idea is that when you leave the course, you're going to have something which is excellent. I like to think of it as a CV on steroids, which is probably a very inappropriate term, but you get the idea of what we're trying to achieve through the professional portfolio. So don't stress about it. If you're not able to produce it just yet, please do so. And do make sure that when you provide me with a link to your video, I can access that video. Every year I access videos, and I'm told, or I try to access the video, and I'm told that I can't. Nicholas has provided some excellent information on UCrew, which I'll upload to Moodle as well, in relation to some of the technical aspects. If you're having problems, I'd urge you to look at that material, and Associate Professor Scott Beattie has also provided some excellent technical material. All right, before we start what I have to say tonight, are there any questions generally or about the assessment? Okay. This week, next week, the week after, you'll hear me doing a lot of talking. I'll be introducing you to a lot of websites. It's going to be more in terms of a lecture format the next few weeks. Later in the course, it becomes much more interactive, and that's where I'll be looking for you to contribute in a much greater way. I do urge you to continue to upload your responses to the weekly problems. I do monitor those. I haven't added a lot of material, but I will add some material selectively. And part of the reason that I want you to do those weekly exercises is that they will hold you in good stead when it comes to you producing work later in this course. So you're preparing things that you may well use when it comes to the toolkit or the briefing paper. All right, so tonight we'll start with a recap of sources of law in Australia. You should be reading your text. You should be doing your supplementary reading, whatever that might be, and we'll give you some hints as to what that could mean tonight. You need to read in advance and make the most of these weekly sessions that we have. I want you to keep it all in balance. I want you to remember, of course, that it is important that you keep up your fitness level, keep up your sleep, eat well, don't drink too much alcohol or take drugs that you shouldn't take. The reason I'm saying that is that, as I mentioned in week 1, it is quite stressful studying law. It's stressful practicing in law, but it's very rewarding. But you do need to look after yourself. So manage the expectations that you have of yourself and manage the expectations that others may have of you. Ultimately, it's up to you. And I do stress this. I want you to enjoy the process. And most of you seem to really enjoy the process of learning about law. And what we're going to do tonight hopefully will enforce that rather than take that away. All right, so we know that our law, and this is just a recap of last week's, fairly briefly, we know that we have primary sources of law and secondary sources of law. Primary sources, legislation and case law. Law made by Parliament, law made by judges. We know that the law made by Parliament will override the law made by the judges. So they're our primary sources of law. We also know that the law is made at different levels, both in terms of statute law legislation, which is made through the Commonwealth Parliament and through the state parliament, and to some degree through delegated legislation by local councils and other bodies. And case law is also made at different levels. Of course, the High Court is the highest level in Australia. It wasn't previously until about 1986, I think, with the introduction of the Australia Act. The Privy Council in England was the highest court of appeal in Australia. Now, of course, it's the High Court. So when we talk about case law, bear in mind that it has persuasive effect or it has binding effect depending on the level of the court that we're talking about. So a decision made in a tribunal has little binding effect, if at all, but a decision of the High Court has binding effect on courts below it. In terms of delegated legislation, I did post something on UCRU, which was an extract from John Carvin's publication, and that explains delegated legislation very well. Speaking of UCRU, I'm very much encouraged by the level of participation. The contributions have been good. People have really taken ownership of UCRU. That's exactly what I want you to do. So please, keep it going. It's great. All right. Now, you should know how... yes. Sorry, was that someone? No. As I mentioned, this week there's been a lot of talking from me. Sorry about that. But that said, please feel free to unmute your microphone, ask a question, make a comment, or use the chat facility. That's always on the go. Okay, so by now you should know the basic way in which legislation is made. You should know that law is introduced by way of a bill through Parliament, which considers it. It goes through a number of readings. I want you to think about the second reading speech. Okay, so when you're looking at the way in which bills make their way through to become acts of Parliament, the second reading speech is really important, and that's from a statutory interpretation perspective. It goes through committees, it goes through a third reading, ultimately becomes law. It becomes law upon what process taking effect? I'll just pause to see if someone wants to tell me what is the final thing that ultimately causes an act to become effective.
That assent?
Royal assent. Thank you, Mo. That's it. So royal assent is necessary. Think about assent, says Job. Yes. I want you to have a look at two pieces of legislation that are relevant to the question of when a law becomes effective. In Queensland, the Acts Interpretation Act, that's the ACTS, Acts Interpretation Act, 1954. Have a look at section 15, capital A.
Immediately.
Yes. Well, that's right. So section 15A, you don't have to look at it right now, but do look at it at some stage. And at the Commonwealth level, have a look at the Acts Interpretation Act 1901 and look at section 3A. The Commonwealth provides that through section 3A, the effective date of the Act is 28 days after the date of assent. That's if the Commonwealth Act does not contain a date of commencement. And in the Queensland Act, if the Act does not contain a date of commencement, then section 15A provides that the effective date is the date of assent. So there are those slight differences. Okay, if you want some further information in relation to the way in which laws come into effect, I really think that you can't go past the Parliament of Australia website. I'm going to share that now. You should probably all have looked at that already, but if not, here's what it is. I'm sharing the screen. Hopefully you can see the Parliament of Australia website. Please let me know. Is that yes? You can see that? All right. So it has some excellent material. It's a very good website. I want you to just enjoy the process of reading about these websites, following the links, exploring what's there. If I could draw some things to your attention, we have, of course, the Parliamentary Library. The library contains links to bills digests. It contains information that you should consider. The Parliamentary Handbook, for example, and there are research publications. So when you follow the Parliamentary Library, you'll see the Bills Digests. So I've extracted one of those as an example. I'll leave that site now. And here is the Bills Digest for the Environment Protection and Biodiversity Conservation Bill as it was in 1998. It's now the EPBCA, the Environment Protection and Biodiversity Conservation Act of 1999. Now, the reason I'm asking you to look at these Bills Digests is the same reason that I asked you to consider the second reading speech. And that is that these things are very important when it comes to interpreting the statute. I do take in third term statutory interpretation. Many of you would be studying with Wayne Jones statutory interpretation at the moment. So Wayne has probably gone through some of these things already, if not likely to do so down the track. But the Bills Digests provide information which were prepared for the debate about the Act and were written to assist members of Parliament in their consideration of the bills. So it provides valuable information that you can rely upon if you're trying to argue about the content of information. All right, so we'll now go to the, I'm sorry, I should have gone back to the Parliamentary Library website, and I'll do that now because there was one thing I wanted to show you, and that is the Hansard link. It's pretty easy to find. If you go to the Hansard link, you can read about the parliamentary debates, and again, that's valuable in terms of, potentially valuable in terms of determining what was intended through the legislation. All right, I'll just stop the share now. So can I just have an indication, has everyone been following up on websites, official websites? So I've shown you the Parliament of Australia website. I hope that you can see through that, from that there is valuable information and material that you need, not just out of interest for this subject, but things that you need in practice. You remember in week 1, I said I'm tailoring this course for those that intend to practice. So I'm showing you these things because you will need them in practice. All right. One thing that I may have mentioned briefly last week is the concept of the Crown. I'll just mention it briefly again. You will see this concept from time to time, the Crown. Governments go and come, they come and go, but the Crown remains. The way I like to describe it is, it's perhaps a bit artificial, but think of the Crown in the context of the overall structure as the household is to a household. So you've got members of a household, you've got mum, dad, the kids, grandparents. People come and go from the household, but the household always remains despite the individual personnel within the house at that time. So it's a bit like that for the Crown. So you've got the Crown, which is always there. It's the sort of the repository, if you like, and members of Parliament, governments come and go within that concept. So when you're reading about land law, for example, you'll see that all land and natural resources in Australia, subject, of course, to native title, derive from the Crown. They're not owned, they're not government land, but it's Crown land. So, the private ownership transfer by way of fee simple, which provides the greatest degree of ownership, if you like, to a private person, is still subject to reservations to the Crown in relation to mining and petroleum. So if you look at a title deed to property and you see that someone owns a property freehold, it's still subject to that reservation about those things which are retained by the Crown. So the Crown is not the government, but the government is responsible for the affairs of the Crown. The people within a family are still responsible for the affairs of the household, if you can follow my logic and that parallel. So sometimes you'll hear about legislation binding the Crown, and that means that institutions of government must comply with the legislation. All right, are there any questions about the concept of the Crown? I've tried to explain that in a reasonable way, hopefully an understandable way. No questions, we're all good? Okay. All right, so I mentioned that the primary sources of law in Australia are legislation and case law. We'll just talk briefly about case law. You'll understand, and you should now understand, that there's a doctrine of precedent. Courts follow previous court decisions, but only if that court decision is binding upon it. And to get an idea of the hierarchy of courts in Australia, have a look at figure 5.5. It's on page 163 of your text, and you'll see that that's a flowchart of the hierarchy for the federal court system. And the state system is much the same, and it's on the page 165. So what's on page 163 of your text is accurate, except we no longer refer to the court mentioned at the bottom as the Federal Magistrates Court. It's now the Federal Circuit Court. I'm sure many of you knew that already. But otherwise, it just gives you an idea of the way in which the system works and the hierarchy of courts at that federal level. And you'll see there that most courts have what we call original jurisdiction and appellant jurisdiction. And most courts have criminal and civil jurisdiction, but not every court does. So there is that mixture of whether the court does have power to deal with matters which are originally brought to it. So when we talk about original jurisdiction, we're really talking about something that has been brought to the court for a determination at first instance, as opposed to something which is brought to that court by way of an appeal or a review of something else. An appeal, I should say, not a review. So most courts have that appellant and original jurisdiction, and most courts have the ability to deal with both criminal and civil matters, but not every court does. We mentioned the difference between common law and equity. I hope I know I'm moving fast tonight, but it'll be like this for a few weeks. I mentioned the difference between common law and equity. Common law, black letter law, equity, interests of fairness, what's just. The Judicial Act 1873, they merged. But not every court necessarily has equitable jurisdiction. So just be aware that, for example, if you go to the Magistrates Court, there is some orders that you might get in a district or Supreme Court, such as a declaration or an injunction, that you can't necessarily get in all areas of law in the Magistrates Court. I know that's confusing. Just let it flow over your head for a little bit for the moment. But what I'm really trying to say is this, and we'll talk about this in a minute. Some of the monetary jurisdictions that we read about with respect to these courts are a little misleading, in that it's not just the money or the value that you need to consider. There are other aspects that may have relevance when it comes to deciding which court your matter should be litigated in. There I'm ending a sentence with a preposition, which I don't like doing. Sorry. All right, are there any questions?
No, that was as clear as mud, John. It's all good.
Very good, great. All right. But you did understand the bit about letting it flow over your head a bit, so that was good? All right.
All good.
Excellent. All right, lesson learned. We can talk more about that on New Crew. So another thing that you'll learn about with case law, and you may have read about this already, is these funny distinctions between reported decisions, unreported decisions, and reports that are authorised reports and unauthorised reports. Have you come across that in your reading? Okay, just briefly. Reported decisions are decisions that are recorded as part of a set of decisions, set of reports. And the publishers of those reports choose to include certain cases as part of those reports. So not every case that is decided by a court is recorded in writing, ready for people to read. So when it comes to, say, the Commonwealth law reports, you're really only going to read those decisions that are of significance and importance, although I mean, that's the High Court, so that'll be all of them. That's a bad example. But if you're reading, say, the state reports for Queensland, then it won't be every case. It will only be those cases that actually have some merit in terms of providing some insight into the law or in the way in which the law is applied. So we have publishers who choose which reports are reported. So that means that there are other decisions out there which are not reported. They're unreported decisions, but they're still of value in certain circumstances. So if you see an unreported case, it simply means that it's not part of a formal report series. That is, there's no publisher, there's no necessarily printed report, but it's still available to you in many instances. So when you're reading through your databases, citators, you'll see reference to unreported decisions. And the way in which it would normally look is like this. You'll read it as X against Y. Now, when I said X, I meant party A, and Y, party B. If I say X against Y, how do you write that? You don't write the word against. That's a big hint. What do you put instead of the word against? Yes. Oh, you're all flying in with this one. Small v. Thank you. And don't go into court and say Smith versus Brown. You say Smith against Brown or Smith and Brown. So later on, in evidence, for example, you'll read about and talk about the ruling in Brown and Dunn. We all know when we say Brown and Dunn that we mean Brown v. Dunn, but you don't say the v and you don't say versus. Okay, so you can say against or you can say and. All right, so unreported decisions, what do they look like? How do you write them out? What will they appear? It'll be X against Y or X and Y, open brackets, unreported. And the word will actually be there, unreported. And then it'll be comma, the name of the court, district court, comma, then the name of the judge, Devro DCJ, or Devro SC DCJ, comma, then the date of the decision, close brackets, and then the page number. So that's what a citation to an unreported case will look like. Okay, let's keep moving. So I mentioned that you don't necessarily choose a court based only on the value of the dispute. I'm talking civil matters now. So civil matter, let's talk about the 4 options that you will need to typically consider in a civil sphere for the state jurisdiction. We have QCAT. QCAT has 2 divisions in terms of monetary value. The first is its minor debt jurisdiction, the limit on matters that come before the QCAT tribunal, where it's a minor debt. Can anyone tell me the upper limit, dollar limit for that dispute? No, not 10,000. Used to be. It's gone up.
Is it 15,000, John?
15. No, we'll go higher.
50,000?
25. 50,000 too much. Thomas has got it, 25,000. So very good. So for a minor debt in the Queensland Civil and Administrative Tribunal, the upper limit is $25,000. Now, what if it's before QCAT and it's not a minor debt? And if you go on the site, you'll work out some things are minor debt and the rest are not. So by default, everything that's not a minor debt is something else. What's the upper limit for QCAT if it's not a minor debt? Another auction? You're all scurrying looking at your...
150.
150? No, it's more than that.
Oh.
Queensland, so for example, if it's a building dispute in relation to a residential building contract, Melissa says 750,000. No, it's more than that. It's unlimited. So in the Queensland Civil and Administrative Tribunal, if it's not a minor debt matter, so it's and minor debt matters, just have a look at the at the website for that. If it's not a minor debt matter, it's unlimited. All right, so Magistrates Court, what's the upper limit in terms of money for the Magistrates Court? We have any bids?
25.
25 used to be, it's gone up now. And this is the Magistrates Court.
75.
75? No, it's got more than that now.
Is this the one that's 150?
150, that's it.
I thought I remembered something where that
That's
was
it. So Magistrates Court 150, District Court, upper monetary limit.
Just 750.
750. Oh, 750 said with a question mark, James. We'd prefer it if you said 750. But you're right.
Yeah. Cool.
That's
good enough for me.
Very good. No, it gets a tick. And of course, Supreme Court is unlimited. All right. So just bear in mind, the first thing is if you're dealing with a civil dispute, think about the dollar value. That will certainly have a bearing on which court or tribunal you proceed through in resolving that dispute. But just make a note to yourself at the moment that there's more to it than just the money. All right. So we'll come back to that over the course, and we'll do more of that sort of thing in week 8. Now, remember that in a court process, there are 2 types of proceedings. One is adversarial. That's what we use almost all the time. But in other jurisdictions overseas, in the civil law countries, they have what's called an inquisitorial approach, which is where the member of the tribunal, the judge will actually make inquiries. We do have an inquisitorial approach to some degree in Australia, for example, in tribunals, which are not bound by the rules of evidence. Then it may become more inquisitorial proceeding. So remember there's that difference. Okay, we're moving fast. You're doing well. You're keeping up with me. Addressing the judiciary. If you're in court, how do you address a magistrate or a judge?
Your Honour.
Your Honour. That's it. Spot on. Thank you. So, Your Honour. If you're in a tribunal, typically, how do you address the member of the tribunal? Not justice. Member is the usual designation. At a social function, if you meet with, say, a district court judge, what's the usual protocol, particularly as a member of the profession? So you're at a...
Do you say justice?
No, not in a social context, I wouldn't.
Yeah.
So
Judge?
Yes, judge, spot on. Thank you. Is that Sundari? Thank you. So judge is the appropriate terminology, respectful. So it wouldn't be Your Honour in a social function, I wouldn't think. You can, but I would normally go with judge. Okay, if it's a magistrate, how do you address a magistrate, him or her, in a social setting? Mr. or Mrs. Same for a tribunal member. All of these, of course, are subject to an invitation that the judge or the magistrate or the member may make to say, please address me by my first name. So you'll get that from time to time, but the default position is always more formally. Okay, look, I'm just going to move now across into some legal research. I know this is jumping ahead a bit, but I really want you to do a lot of work in terms of legal research. We're going to stress it tonight to some degree. We're going to talk about legal reasoning as well, and then we're going to come back to legal research. I mentioned in week 1 that you can get used to me jumping around the areas a bit. I did mention that you need to learn everything at once. So true to that statement, let's do a little bit of legal research. I had planned to tell you something about criminal law procedure and civil trial procedure, but I won't have time, so we'll do that maybe later in the course. Legal research. have we started to investigate the sources of our law, where we look to find legislation, where we look to find case law? Have we started to do that? I hope we have. It's fun, a little bit.
I have a little bit. I'm having to, because I'm doing statutory and constitutional as well. So it's
Oh, okay.
John.
Yes, Nicholas. So yeah, if you're doing those subjects, it will be the unit coordinator will assume that you've done some legal research and you've got some legal research skills. All right, I'm going to be honest with you. I've got an ambition for this group. By the time you finish, you are all going to present your material extremely professionally. Okay? That's going to be a given. People will look at your material in years to come and say, you must have been part of that famous CQU Term 2 2017 group, because your material is just so well presented. This is excellent. The other thing is that you will be known as that group that are unbelievably good at legal research. They're the two key areas. You're going to be famous in years to come, this group, because of your abilities in those areas. All right, so let's look at legal research. Having said that it's really important, where would we look when we want to find legislation? I think the first point of call should be the Federal Register of Legislation. Let's share the screen. You should hopefully see my desktop. As the name implies, we're now talking federal legislation. This is an excellent website. It's relatively new. It used to be ComLaw. Before that, it was Scale Plus. They weren't very good. This one's good. So I like the Federal Register of Legislation. Let's go back to the home. It looks like this. We've got these lovely looking tiles. It's beautifully laid out. And if you haven't visited this site, please do so now. So Nicholas has put up the web address for that, www.legislation.gov.au. So this is where we find the authorised whole of government website for Commonwealth legislation and related documents, and it says that right there in the left-hand tile. You'll see we have the acts in force, we have the bills as introduced, we have information, which is where I'll take you now, and other information about legislative instruments and gazettes. This is a really good website, so please become familiar with this one. I mentioned information. We have really easy to read information about this Federal Register of Legislation, which is called the Legislation Register, how to use this legislation register. So when we talk about the Federal Register of Legislation, the other name for it is the Legislation Register. So how do we use this legislation register? Information about legislation, structure of the law, sunsetting lists, legislation tables, etc. I'm just going to ask if you spend some time just enjoying the process of reading through this material and getting to know it a bit, get a feel for it, and we can move on from there. I will come back to this Federal Register of Legislation often, so please have the link ready to go and read about it. Okay, at a state level, the website is not good, but there is good news coming. The new beta website is about to become launched, or should be launched. It said mid-2017. We're not there yet, but it's getting closer. So the new website is much better than this current one. But for the moment, this is where you find the authorised legislation for Queensland, acts as passed, bills, repealed legislation, etc. I think it's fair to say, for the most part now, many practitioners and others go to AustLII first up. If you haven't been to AustLII, please do so. It's excellent. www.austlii.edu.au. It's part of a worldwide organisation. in terms of providing information freely, and it's available, freely and readily available. It's a joint facility of UTS and UNSW, Faculties of Law. It's excellent. It's absolutely free, but you are encouraged to contribute, and you'll see the big yellow sign over there on the right-hand side. Do look at this website, and we'll come back to this often. It's got some excellent research functions that are all available to you. Okay, I'll stop the share now. So we've started to do some work on legal research. Okay, so please keep that going. And if you want a break from what you're studying, just go onto some of these websites and just spend an hour or two just poking around reading them. The time goes really quickly because you're going to have, I'm sure, when you look at these websites, a lot of these, oh wow, look at that moment. And I mean that seriously. You'll think, okay, so now I can see where we find the explanatory memoranda, which is important for statutory interpretation, and there it is. Well, now I can see what cases have been decided recently with respect to that particular section of the Act. Okay, I'll remember that for the assignment. But you'll remember all these things in practice too. So they really are useful in practice. They're not just theoretical exercises. Okay, so we'll talk more about those websites as we progress, and I'll keep jumping back to them because we're going to be very good at legal research. If you want some information about legislative instruments generally, there is a thing called the Instruments Handbook. I'm just going to call that up, and this is through the Office of the Parliamentary Counsel. I'll share the screen and we can have a look at that. And I know I'm moving fast, and you may have to come back to this session a couple of times, but you'll see there the Office of the Parliamentary Counsel, and we have information about the, where is it? The Instruments Handbook. It says there that it replaces the Legislative Instrument Handbook. It's been renamed. So it's got, it's the third one down. You can see it in PDF, and in Word, I'll just open it in PDF. It should open. And this is really useful because it's a document that's prepared to help rule makers and government bodies undertake their work. Sorry, I'm having trouble with my mouse. It's running all over the place. So you can see part of it there anyway. So the legislative, the Instruments Handbook, as it's called now, includes information about the key concepts of preparing legislation, drafting and interpreting the instruments, parliamentary scrutiny, and sunsetting. So some of these documents that I'm providing to you are the documents that are used by the people that are actually making these things happen. And that can be a valuable guide to preparing documents or working through documents and interpreting documents. Okay, I'll stop the share there. All right, so case law. So that's a really brief introduction to legislation. We'll come back to that. Case law, where do we look for case law? Can anyone tell me any websites? Have you found, and I mean, if you wanted to find a case, I mentioned, for example, Brown and Dunn. If you wanted to find a case, whatever it's called, where would you look?
Westlaw.
Westlaw is an excellent place to look. Where else? And how would you access Westlaw? And don't say Google. I mean, you'd get to Westlaw through Google.
No, it's you have to go through the CQU University Library to get to the Westlaw at the moment.
Exactly. Yes. So has everyone been to the university library? We'll talk more about it tonight or next week as well. That's a few yeses. Some great resources there available for you. Westlaw's there.
And the other one through the library, John, is LexisNexis.
Mm-hmm. They're the big two, I think. When I go to the library, electronic library, for me, LexisNexis, Westlaw, There's CCH, don't forget CCH, that's very good as well. But the big two really, I think, are Westlaw and LexisNexis. They're subscription services, so the university pays for those. They're freely available to you. They're expensive services, but they're very good services. Are there services that are available for free where you can access case law? No? We've shown you one tonight. Ostly.
Ostly's one, yeah. What about Commonly?
Yeah, commonly. Yes, yeah, commonly. Sorry, I'll just mention commonly. So commonly is, if we're talking about the same thing, is part of that same group. So Ostly is the, and there's Barley, which is for the British version, Jade Barnett, yep, we'll get into that one. But commonly, actually I've got a link to commonly. I'll call it up now. So commonly is the repository of legal information which is available free for Commonwealth countries. I'll just share the screen. So this is like Ostly, but it's for the Commonwealth. And was that Nicholas who mentioned that before? I think we're talking about the same thing.
Yeah, we are, John. I've put the
Great.
link up in the chat as well. Just
Oh, great. Thank you. All right, so there's commonly. All right, so commonly is really valuable if you want to find English cases, particularly. That's where I would go, or through one of the paid services. But you'll see here links to Australia and to the United Kingdom. So that's where I would go if you're looking for some English case law. But it's not just case law. It's also got legislation. You see, this is the English reports, going right back to 1220, right there, if you need any of those really old cases, which you may need from time to time. I don't think you probably refer much to some of these other things, Tanzania, etc., but certainly to the United Kingdom, possibly Canada, and possibly New Zealand. But I would have thought the UK, from where a lot of our common law is drawn, might be the reason to go to commonly. Okay, I'll stop the share there. Now, someone mentioned Barnett Jade. Excellent, really good, free service. We'll have a look at Barnett Jade. So Barnett created Jade, and I'll just share the screen so you can see it now. You've got to look at this website, and you've got to look at Ostly, and I would look at commonly as well. But Jade is excellent. All right, so Jade, we'll talk more about it later, provides up-to-date information in relation to cases. You see that GAX against the Queen? I don't know if you noticed that. So that's there as a recent High Court decision from the 21st of June 2017. If we go back to Ostly, you'll see it's there as well. 21st of June 2017. So it's brand new decisions. And when it comes to these recent decisions of the High Court and other courts, they're likely to pop up first in places like Ostly or Jade, as opposed to some of the official repositories for information. So do have a look at those websites. We'll return to those because they're really important. So when it comes to case law, and I'll just stop sharing the screen. When it comes to case law, I think Ostly, think Jade, and think probably Lexis and Westlaw, maybe CCH. Do spend some time looking around those, because we'll be talking about these things for the next couple of weeks, and then we'll be putting some of these things into practice. There are other places that you can look more generally for legal information, and we'll deal with some of those now. I'll share the screen. And
Can I ask a question, John?
yes, please. Thanks.
So 20 years ago, the last time I worked in a law firm was 20 years ago. And I mean, I wasn't involved in research at that point. I was a legal secretary. And but the internet was not the source of all knowledge at that point, where did people find this information then?
All right, well, I'll give you some ancient history. Maybe I've told you some of this, but when I first started, so I left school in 76. I started University of Queensland 77, so I went straight to law school. In 1977, in the law library at the University of Queensland, there were just books everywhere. So everything, if the book was available and it was in a volume, then fine, you could read the case. If it wasn't there, too bad, you have to come back later. So it was all books. I remember sitting at desk and I was very conscientious and I'd make all my notes and I'd work my way through lunch sometimes, and there was a no eating policy at the university library. And I remember on one occasion I was just quietly eating my Vegemite sandwich, reading through and making my notes, and this hand came down on the back of my head, and it was the law librarian. And he said, there are two types of rodents in this law library. There are the people that bring food in, and then there's the rodents that eat the scraps when they've gone. You're not allowed to eat in this library. So, so that's what law libraries were like. They're very, very, very formal places. When I first started in private practice, what we used to do is we would have the legislation purchased in hard, in soft cover volumes. And as amendments came in, we would get the Amendment Act and we would cut out the sections and paste them in over the top of the section of the Act. So an Act had all these floppy bits lying out, and that's how you read legislation. What it meant was it was really tough if you were on your own or you were regional. It was really hard to access the law. And so now having the internet means that we are much more on a level playing field for those of us in the regions like me. So that's what it was like in the old days. So all of this is new. The internet is just new and it's growing so quickly. So you've come in at a good time to be studying law now. Sorry for that digression. I hope that answers your question, Sundari. All right, so Legalpedia. Let's have a quick look. I'll just share the screen. I know we're not getting to the material which is scheduled for week 4. We will cover it, but the next few weeks are just going to be combined 3, 4, 5, 6 over the next probably 4 weeks. Share the screen. This is a good one. Legalpedia Queensland. This was, it's an online legal database. It's hosted by LawRight, which was formerly the Queensland Public Interest Law Clearinghouse Incorporated. And it's got some useful information. Good place to have a look to start with. Another is the Queensland Law Handbook. This is produced by Caxton Legal Centre. Caxton Legal Centre is famous. It was started off when I was at law school. I have the actual handbook. See that book there, the red book? I've got that version. I think the last one that they put in that form. I'm not sure you can buy them anymore. Perhaps you can. But what you can do is now access that content for free over the internet. So you can browse the entire handbook, section and chapter, and it's a great introduction to information which is up to date, relevant to Queensland. It's meant to be, and it is easy to read, but it's authoritative and it's informative. So I would urge you to have a look at that. The Queensland Law Handbook, produced by Caxton Legal. An often overlooked place to look for legal information online are the official locations. So here we have the Queensland Courts website. This is excellent, and I'll show you just a couple of little places that you might want to be looking at. The daily law lists tells you what matters are on, so you can look at what matters are before the courts tomorrow through that list. So if you're ever interested in going to a court, and I do, I'll print that daily law list out for, say, the Brisbane courts, and I'll know what's happening before what judge in each of the courts and go and watch some of the cases.
Can I just ask a quick question in
Yes,
regards
David.
to that?
Yeah.
Are there some court courts that we're not allowed to go into, and we need to ring ahead to find out whether that's, or is it, because there are some that's closed to the public, isn't there?
Yeah, no, that's right. So generally speaking, domestic violence courts are closed to the public. Children's courts, are they still closed to the public? It's a while since I've been in the children's court. I think they are still closed to the public. So those sorts of courts are closed to the public. There are some other, like, so the Mental Health Review Tribunal, that's a closed jurisdiction as well. Mental health court in some ways is closed, but most of them are open. So they're free to go in. The Court of Appeal, for example, is.
Can you call ahead? Would you be able to get someone helpful enough that might say, look, you're not really going to be able to go in that one, or look, you might be able to go into that one? Is there any easy way to determine which ones you can go to or not?
Yeah. Well, again, if you're in Brisbane, if you're in the CBD and you go to the courts complex, it's easy.
Yeah, I am. That's where I'll be going.
Oh, look, so that's so easy, because if you print that daily law list, and I would recommend you print it and take it with you. If you're going there for a day, and it's a really good day, just have that, and then you'll know that in court on 27 on level 9 or whatever it might be, judge such and such is hearing these matters. It'll have a list. The easy way is on the door, it'll actually have a sign, closed or open. So you'll know, because you just look and you see closed court, don't go in there. Go to the next one and have a look there. So you've got easy. You could fill a day easily. Go up to study room number 5 on the 12th floor. Check it out as well while you're there. If you're in the regional areas, yeah, you probably do need to check. But if you look at the daily law lists, it gives you a good idea of what's on. But most are available and free to the public. I'm amazed that people don't wander into QCAT when we're doing guardianship or some quite interesting things that we do sometimes.
I nearly went to QCAT. People can represent themselves in that, can't they? Is that correct? You don't have to have legal representation in QCAT at all. Is that correct?
That's right. And, well, you don't have to have legal representation in any court, even the High Court. You can represent yourself if you want to. But in some courts, in some jurisdictions, the reverse situation applies, in that in order to have a lawyer, you need to obtain the consent of the tribunal or the court. But mostly lawyers are allowed as a matter of course, but not always. So in some jurisdictions, like QCAT, you do need to apply to have a lawyer represent you. So the default position is reverse of what it would be in a court. So do have a look at that. If you don't go and have a look at a court, you're at a real disadvantage. And it's fun. It's a fun thing to do. Make sure your phone is off or on silent, at least, if you go into a court or a tribunal.
Sorry, just one other question. Can you enter and leave the court as you wish, or is there formal proceedings that you have to follow?
Can. No, you can. It's not like a play where you have to wait for an act to finish. You can enter while the proceedings are current, but do be respectful. Try and do it as quietly and as efficiently as you can. And it is very important as law students that you acknowledge the court by bowing to the court, not a full-on 90-degree bow.
Yeah, no. Bow on the way in and on the way out. I've been into that court several times in the last few months for different reasons, and to watch trials and proceedings, and I watched all the judges. I mean, the lawyers do it on the way in and out, and I thought, well, if they're doing it, there must be a reason.
Absolutely. And it's a sign of respect. So it's more, and it's not just a nod of the head, and it's not a full-on bow, but it's like your head and your body moving together by way of an acknowledgement to the court. I hope that makes sense. But do that, and you can stay for 5 or 10 minutes or for 3 hours, whatever you prefer. Try not to be too disruptive, though, if you're coming and going. Okay, so that would be excellent. So if we just share the screen, the other information on the court's website, this is the Queensland Court's website, is so court forms. And this is a really good thing. Search civil files. I know I'm digressing a bit, but you can search party files. For example, in the Planning and Environment Court jurisdiction, you can actually see the documents that are filed. So just play around with that and have a look at some of those interesting websites. The other thing is the Supreme Court Library has some great resources, particularly for court decisions. I'm calling that up now. I know I'm giving you a lot of homework to do, but these are things that you can have fun with and treat it as a little break sometimes from studies. So the Supreme Court Library website is excellent. You can register when you're a practitioner, so I'm registered, of course, and there's some really interesting things here, such as the Queensland Sentence Information Service. You can register if you're practicing in that area. For the legal profession, so you fit within this area, have a look at the Queensland Legal Updater is great. You can subscribe to that and get information sent to you every day. Jade has a similar thing, which really you should take advantage of that. What else can I show you on that? Oh, there's the courts case law is here, and that's worth having a look at as well. So see these cases that are published, the Queensland decisions. I get an email every day from the court with this information. So published the 28th of July, those decisions from the QCA, the Court of Appeal, or the Queensland Planning and Environment Court, or the District Court, QDC. So lots and lots of information there. Worth having a look at. Sentencing remarks are really good as well. You can actually see what was said in those courts.
John?
Yeah.
Earlier you were talking about, you write it as and such. Do you always put either the plaintiff first or the defendant first?
I just
You're
missed
on
that
mute,
question.
by the way. Oh, no, you're back.
I missed the first part. The connection was lost there. Sorry, Sundari.
That's all right. The earlier you were talking about how to write. Okay, so it's such and such v such and such. Do you always put, say, the plaintiff first or the defendant first, or doesn't it matter which way you go?
Usually, if it's a civil case, it will be plaintiff against the defendant, but that can reverse on appeal, where the defendant may become the appellant, which will be the defendant first, against the plaintiff, who is now the respondent on the appeal. So it may be, at first instance, in the Supreme Court, in the trial division, Smith and Brown, but when it goes to the Court of Appeal, it might be Brown and Smith. Does that make sense?
It does. And in criminal, is it always R first?
Yes. R against Smith.
Okay, thank you.
Thank you. There are some exceptions. For example, if you've got a decision of a magistrate and it's the subject now of an appeal in the district court, which is what we call a Section 222 appeal under the Justices Act, then it will be the how do we write this? The such and such against the police. So I'll have to look at the last one I did, but yeah. So it changes slightly in different ways.
Yeah, because the Humsey Hancock case is written Humsey Hancock, comma R-E.
Yeah. So that's a shorthand version of regarding the matter of Humsey Hancock. And that was just a bit different. So that's where a party essentially seeks a declaration of some sort. You might see that type of...
But they're not actually against anyone.
No, it's more a case of, regarding this matter, we'd like the court to make an order. So it's not necessarily your standard litigation dispute of Smith against Brown.
Thank you.
Yeah, Smith and Brown, they really had each other all the time, as far as, if you listen to me.
Hey, John, I just had a quick little technical point that people might like with some of these websites, like legalpedia.org as an example. You know, when you go to bookmark a website, what you'll notice is under the option to bookmark is subscribe to this page. It's generally what they call an RSS feed, And in the RSS feed, they give you all the updates and amendments that are actually made to that website in real time. So if you subscribe to the RSS feed, you're getting constant updates on what's happening. So if you go up to bookmark.
I'm not good at this, so where is bookmark? Where's bookmark? Am
Try
I
your
close? Hey?
Yep, that's usually a bookmark there, I think.
It's greyed out on this one.
You've got 3 little elliptical dots on the far right. There should be a drop-down list in there somewhere. And you can change how your site is designed and what your settings are. And you can set your settings to show subscribe feed. If you will let me share my screen for a second, I can show you how to do that.
Absolutely. Now,
where is the option for me to do that here?
I'll just stop the share at this end. That might help.
Yep.
And can you see the share screen icon at the bottom of your page?
Yep.
All right.
I can. So I'll
Thanks,
just
Nicholas.
do this one and share screen. Hopefully that'll come up for everyone in a second.
It has. Thank you.
Okay, so I'm on this site. I just go up to bookmarks, and in the drop-down list, there's subscribe to this page. And when you click on subscribe to the page, what'll happen is it'll actually go through and it shows you all the recent changes. Can everybody see that? So you get all the recent changes by clicking on bookmarks and then subscribe to the page. So it shows you everything that's been updated all the way through that site and when it was updated. So it's a handy, it doesn't work with every site, but it is a handy way to do live broadcasts and live updates.
That's excellent. I can't see that on mine. Does it depend on the browser that you use sometimes?
I'm using Firefox, but you can either use Firefox or Google Chrome. Either one of those will do it. Internet Explorer generally doesn't have it. Opera doesn't have it. And I think some of the default ones that come with Apple don't have it either. But you can, doesn't matter what system you're on, you can get Firefox for your system. It's free. So once again, if I just go back to this site, so you go to the website, go to bookmarks, and then go to subscribe to this page. You can see that link there, and then it will take you through to the subscription, and you can just click on the subscribe button to subscribe, and it'll show up in your email every day. Within seconds of them updating that site, you'll get a notification.
That's excellent. Thank you very much, Nicholas. And the same sort of thing applies to the Supreme Court Library, where you get those updates, and Jade. And if you do that, could you imagine how good it would be to provide some material relevant to something that happened yesterday if you're in an examination context? I may have mentioned that before, but certainly that's a great way to keep up to date where the information is fed to you. Thank you very much for that, Nicholas. I really appreciate that.
Welcome.
All right. We better wrap it up for tonight. The only other thing I was going to show you, well, I was going to show you about 1,000 more things, but bench books. If you go to the court's website, try and find the bench books, because they are the guidelines for judges when addressing juries. So if you want to, as it were, find a basic script for judges to use, if they wish, when trying to explain aspects of law, particularly criminal law, to juries, then they may well look at the bench books and may read from or paraphrase the bench books. So it's a great resource. Now, many of the more experienced judges won't refer to the bench books; they know it. But if a new judge was appointed, I think they'd probably look very carefully at the bench books. So if you're doing criminal law, keep those in mind because that's a great way to answer a question with authority. Yes, David?
I work for in state government, and today I was talking to someone I work with. He's a bit older than me. He no longer is a police, but he was a police officer for 25 years. And I actually was having a conversation with him today about how is it that judges kind of explain to the juries that very thing. Because obviously the juries aren't experienced in law. They don't know anything about cases either. So that's pretty much how the judge actually presents it to the jury about, or guides them in terms of deciding on what's being presented to them. Is that where it all lies in what you've just said, is it?
Yeah. Look, I will share the screen. I know we're going over time, but we've got a lot to cover, so this is good. But that's a really good question. So here, for example, from the court's website, I've linked through to practitioners and down to bench books. And you'll see here the Supreme and District Court bench books. And if we take an example, there might be, okay, I mentioned earlier today the rule in Brown and Dunn. So if a judge wants to explain the rule in Brown and Dunn to juries, this is where they may look to make that explanation. Okay. And this is perhaps the wording that they might use. The defendant gave evidence that the complainant's injury was a result of a fall rather than having been inflicted on him. Proposition was put to the complainant. In other words, she was not asked to comment on whether that was the case. The proposition was not put to the complainant. The result is that she didn't have an opportunity to respond to a suggestion, and you do not have the benefit of the evidence that she might have been given. She might have given had she been asked. So that's the premises of the premise of the rule in Brown and Dunn, and that's the way in which the court might explain it. So good observation there, David. Thank you. So have a look at the bench books. That will give you some guide as to what the judges do say when addressing jurors. Thank you. All right. Sorry to have kept you. Any questions before we wrap up for tonight?
No, but I did come across
Yes,
a quick resource during the week that I thought might be helpful. I know we were talking about people going into community legal aid services maybe as early as they can. So I'll put a link up in the chat. It's communitylegalaid.queensland.org.au, and you can go in there and pick your area, whatever town or suburb or whatever you're in within Queensland, and it will list every service that's available that you may apply to go and do some legal work with local legal aid centres.
Oh, that's excellent. That's a really good thing. So thank you. Are you able to put that on UCrew as well, Nicholas?
I'm sure I could.
Great. Thank you very much. All right. Okay. Well, thank you very much for tonight. As I said, this is going to be a famous group one day. I know it. So keep up your legal research. Make sure everything is written professionally, looks the part. And we'll see you next week. All the best. Bye.